The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can see our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock. Again, it's repeated Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. My telephone number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa. The issues that are the areas in which we concentrate our interest and efforts are number one, influencing public policy as it relates to child protection issues. Secondly, we attempt to roll up our sleeves and help people who need one-on-one assistance in working with the Department of Human Services and the Juvenile Court. And that's quite a task. And sometimes families feel much neglected and put upon when intervention comes. And it seems as though intervention is occurring constantly nowadays. The big problem is that it is set up in such a way, the child protection system, while it once may have been a noble cause, has been turned into really a business, an industry. And industries can only survive as they grow and have greater and greater influences over folks. So it isn't like a fire department who hopes that their card games are not interrupted by people who need their services immediately. They couldn't care less if they can go for a week without having a case to take care of. But social workers are different. Social workers would lose their job if there were not cases out there to give attention to. So not only that, do we have overwhelming drive to keep the establishment going in order to keep the budgets going, in order to keep the staffs expanding, and to have greater and greater influence over folks in our communities. So it's actually a backward type of situation. Instead of the department trying to work itself out of a job, doing such marvelous work with critical cases, they look for more and more cases. One of the areas in which they have found the greatest amount of potential marketing, and I use the term marketing here because they're out to market their services, is the area dealing with drug abuse. And if they sniff marijuana, if they sniff another drug, or if somebody says that their neighbor is using drugs, they can seize that case very, very quickly and simply remove the children from the home. Of course, they say they do it with due process. There are some real problems with due process, and we've talked to a gentleman on our program that comes on every once in a while and tells us about some of the difficulties found with inadequate exercise of due process. Don, we also look at the internet, and there is a story, just a recent story that someone picked up on the internet just in the last couple of days, a lady by the name of Barbara Johnson, who is a constitutional lawyer in New England, and she's had her share of problems with the system, because she goes out and tries to help people. And for some reason, there are those who don't care about having people interrupt their little escapades in the legal process. What does Barbara Johnson tell us about due process, Don?
Due process and equal protection are absent from the family court. How very true. Every day in family courts across the, in this case she writes Commonwealth, that refers to her state, children lose one or both parents. The court is causing the Holocaust of American families. Where have we heard the word Holocaust? It's repeating here in the United States. Germany destroyed their people, and now America is destroying their people. Actually, this has been going on probably, probably before we had the battle with Hitler in World War II. And it's just probably gotten worse and worse, but it's been going on here a while, and we're continuing to tell the public of what's going on. The children are the pawns. The court claims what it is doing is in the best interest of the children, but that is not so. The court is doing what will glean the most federal money in the form of bonuses at the end of the year. As people say, follow the money trail. It's not the children, it's the money that the children bring in is what motivates DHS. You cut off the purse strings from DHS, and I'm sure that it would just collapse in a heap. People don't work for nothing. Many of the judges were assistant registers and never read a law case in a decade or more. They were simply political appointments. The Commission on Judicial Conduct must be more proactive in punishing the judges who are remiss. Given that you cannot sue judges, that's in her state, there must be some way to get relief from the wrongs done by incompetent judges. Discrimination against men is rampant. When child support orders are unreasonable and men cannot meet the payments, some greater than their weekly pay, innocent men are found in contempt and sent to jail. When women disobey orders to allow dads to see their children, contempt actions against them are dismissed without hearing. Judges who dismiss complaints for contempt without a hearing should themselves be punished. Wow, what a novel idea. The citizens of the United States, they get punished if they make a mistake. Why is the judges above the law? Fundamental fairness has disappeared. The crimes by the family courts have reached epic proportions. They must stop. Court reform is necessary. Barbara Johnson is an advocate of court reform and an attorney at law. And what state is that, John? I forgot.
Massachusetts. Andover, Massachusetts.
Okay, thanks, John.
Okay, and one of the things she says at the end of each of her emails is this: the judicial system is very broken. It must be fixed. There are 4 people who can do the job: everybody, somebody, anybody, and nobody. Everybody thinks that somebody will surely do it. It's a job anybody can do, but nobody is doing it. At least I'm trying. What are you doing? Well, it's rather delightful to read some of her commentary.
Speak up and say that a little louder. What are you doing?
Okay, you're right. There are a number of things that need to be done in the Iowa legislature, and we're going to get back to that in just a little bit. But before we do that, we're going to talk to someone who, or have someone talk to you, give you a wee bit of a lecture, give you an idea of some of the naughty things that are happening in courts all over this nation. It is, as Don said, an epidemic proportion. Of course, everything, I hear the term epidemic and I hear tip of the iceberg and all this sort of thing. But we've looked into this, and it appears that what is happening here in Iowa is happening all across the nation. There are no real good exceptions. Courts tend to be corrupt. And I think they're not only corrupt, but I think they're going downhill from there. Let's get an idea of what is in today's news by speaking to a fellow by the name of Terrance Walker. Here now, Terrance Walker.
Thanks a lot, John, for having me on the show once again. We weekly or once a month, depending on when I'm available, have time to explore how the judiciary affects us and affects us in a negative way in this nation. I think that you brought some interesting points to light there with that article you read from Barb Johnson, who I also read some of her writings on certain things that she's set forth online as well. I think she brought some very excellent points. Somebody needs to do something about this, because it's going to take all of us to do it. I mean, it's a grassroots effort. Now, we've learned from the example of jail for judges in South Dakota that even grassroots efforts to curb the judiciary's so-called authority have been or can readily be leveled because of the interest involved and the deception that can be involved by the power structure. The Attorney General this past November of South Dakota has implemented a plan to basically derail the Judicial Accountability Initiative in that state, which was an initiative that was signed on the ballot by some 40,000 citizens of the state of South Dakota. Yet and still, when the measure was voted upon, the Attorney General, through his use of deception and deceit, had so confused and obfuscated the whole issue of judicial accountability law there in the state that voters did not even recognize what the measure was when it appeared on the ballot. The explanation was so readily it was just at odds with whatever was laid forth in the petition that 40,000 people signed, that they didn't even get half of the 40,000 people to vote on the measure. So, this is what we're up against. Everybody needs to be involved, because even a large grassroots situation such as that was tried in South Dakota this past fall and for the past year or so before that, it is, it can be derailed by just a small group of individuals, because the judiciary and the legal power structure doesn't want to see change, and because the power base that they've amassed is so entrenched and so crafty that it's not going to be changed without a lot of education and a lot of hard work from a lot of people such as yourselves and such as us. But I ran across a really interesting article. This was actually a paper by the University of Tennessee College of Law professor Benjamin Barton, who just recently, I believe the past couple of weeks, had submitted a paper which is available online. You can look him up, Benjamin Barton. And the paper is entitled, "Do Judges Systematically Favor the Interests of the Legal Profession?" Now, he carefully and painstakingly researched and demonstrated how the judiciary protects the legal profession. And in that same example, which I just pointed to in South Dakota, the legal profession likewise protects the judiciary. So what we're talking about here is foxes guarding the hen house. And he lays forth a set of questions in this that actually demonstrate, along with his examples, the fact that judges do systematically favor the interests of the legal profession and vice versa. Some of the questions that he offers for us to ponder are, for one, why are lawyers the only American profession to be truly and completely self-regulated? Every other profession at least has to push their self-regulatory apparatus through state or federal legislatures. And by contrast, lawyers are self-regulated in the first instance by lawyers or justices from the state Supreme Courts, often as the result of virtually irreversible state constitutional law or judicial fiat. And judicial fiat meaning like a judge-made law, basically, or judicial order. Predictably, this level of self-regulation has been exceptionally helpful to the legal profession as a whole. Another question is, why is it that the attorney-client privilege is the oldest and most jealously protected of all professional privileges? The attorney-client privilege has been protected at common law for more than 300 years. By contrast, there has never been a common law doctor-patient privilege. That privilege has largely been established by statute. Another question to ponder, why is it that the Supreme Court has repeatedly struck down bans on commercial speech since 1970s, except for in-person lawyer solicitations and some types of lawyer advertising? A ban on in-person solicitation by accountants was struck down. And then why is it that a Miranda right to consult with the attorney is protected so much more fervently than the right to remain silent? And when a suspect's asked to seek a lawyer, all interrogation must stop until the lawyer arrives, or a substantial period of time elapses. By contrast, if a suspect says, "I would like to remain silent," the police can wait a period as short as a few hours and resume questioning. This is so despite the fact that Miranda protects the Fifth Amendment right to remain silent and not the Sixth Amendment right to counsel. So why is it that one amendment should be more powerful than another one? That doesn't make any sense. Why do courts flatly refuse to enforce a non-compete agreement against lawyers? By contrast, other professional non-compete agreements are analyzed by a case-by-case reasonable basis. And lastly, why is a legal malpractice case so much harder to make out than a medical malpractice case? And why has the doctrinal broadening of liability for doctors been so slow to reach lawyers? In most legal malpractice cases, a plaintiff must prove a case within a case to be successful, establishing both negligence and that but for that negligence she would have won and collected on the underlying case at trial. By contrast, in many states, a patient can recover against a doctor for a lost chance of survival. So, I mean, there's a lot of different things that we should that we should definitely pay attention to as it pertains to the judiciary and the legal profession. The interesting point that was made, and I think what sums up the whole case that was made in this paper by Professor Benjamin Barton was this. He broke down how the Bar Association is basically unified, is integrated in 36 states and the District of Columbia. In these states, a lawyer must be a member of the state bar and bar association to practice law. This mandatory connection between a professional license and membership in a professional organization is unique to the legal profession. I mean, you don't see doctors having to be a member of the American Medical Association to be a doctor. You don't see barbers having to be a member of the Barber Association to be a barber. You don't see accountants having to be a member of an accountant association to be an accountant. But the lawyer profession, you have to be a member of the Bar Association. So, I mean, I think this is really unique. But the history of the bar unification is definitely instructive on this whole point that he makes that are the foxes? Do the judges basically favor the interests of the legal profession, and why are they guarding the hen house? And is that detrimental? Now, the first states that unified the bar by statute, but in 1939, Oklahoma became the first state to unify by court order. Now, following Oklahoma, the remaining states unified by court order, or court action. And basically, this granted the legal profession a court-created bar structure and an exceptional lobbying and financial advantage, ready, willing, and anxious to self-regulate. And naturally, state Supreme Court justices have generally been granted these bar associations much of the court's regulatory power, and even states without a unified bar state Supreme Courts delegate their regulatory authority to lawyers and bar associations. So from the Supreme Court justices on down, lawyers are regulated only by lawyers, not by citizens, not by hardworking, red-blooded, tax-paying citizens, but by lawyers. The people that are most affected by the lawyers, they have no say-so. But the people that are lawyers have all the say-so over fellow lawyers. So he makes the summation point here is that as a general rule, foxes make poor custodians of hen houses. And he's actually argued in a number of other cases and other legal papers or research papers that same thing, the same point as it pertains to lawyers and some of the other issues. And I think deriving from all of this, we see a case, a prime example of what's transpiring here, in that judges think that they are above the law. And there's an interesting article coming from the Pittsburgh Tribune Review, dated Monday, April 2nd, in which judges are basically going beyond this self-regulation power and doing their own self-action and court action, which benefits themselves and other lawyers. Not only are they doing that, but now they have had basically in the Commonwealth Court, and this is in Pennsylvania, judges in this Commonwealth Court, state judges won't be above the law. They're basically trying to seek a ruling against this, but I don't think that it's going to happen. But judges basically seeking election to higher offices or additional terms could be required to file financial disclosure statements with the State Ethics Commission, just like the law requires of judicial candidates who are not judges. Now, judges have been excluded from the disclosure requirement in Pennsylvania's Ethics Act because in 1983, the state Supreme Court ruled that, are you sitting down? This is the author's comment. Are you sitting down? It would be an unconstitutional violation of the separation of powers to apply the law to the judiciary. Now, believe that, or understand this. So they basically said that it would be a violation of the separation of powers because the judiciary would have to abide by some of the other election rules applicable to any other candidate.
What's the problem with that, Terrance?
Well, that's a result of judicial or lawyer thinking. And one of the other interesting points that Benjamin Barton makes is that law professors, I mean, he's not an advocate of this, but law professors regularly brag that they're trying to train law students to think like a lawyer.
Is that a fringe benefit to have a job that's above the law?
Well, I think if you're thinking like a lawyer in these terms and all this and how this whole institutionalization thought process goes, you think for yourself. So you don't necessarily have to think like a rational person. You have to think in your self-interest and make an argument for your self-interest, regardless of whether or not it makes any logical sense.
You're
So-
talking about an attorney or a judge?
Well, I'm talking about thinking like a lawyer. So this is what we see when they get so personally interested in protecting their self-interest. What they say don't make any sense, but yet they expect the general populace to just accept it, But the general populace
That's you and I.
can look at this and see that it doesn't make sense, but most of us will really do anything about it because they're lawyers. They own the system, they control the system, and we're, for the most part, have no say so, and they can even manipulate the system so that we can't have any say so, which is a prime example of what happened with jail for judges in South Dakota. So in a recent ruling in Pennsylvania, the Commonwealth Court Senior Judge Barry Feudal wrote, "The act of becoming a candidate cannot be construed as a judicial act any more than the act of applying to a law school could be construed as part of the practice of law." And 3 people dedicated to reforming Pennsylvania's Byzantine government shared their thoughts in email messages to the writer of the article here. One of the responses was from President and CEO of the Commonwealth Foundation for Public Policy Alternatives. And he says, my initial response was, what? Incumbent judges haven't had to file financial statements? How can this be in a state where we elect our judges? This only further demonstrates the need for an overhaul of every branch of state government through a citizen-led constitutional convention. We need to reapply the chains of the Constitution that public officials have effectively thrown off. Much more needs to be done to make Pennsylvania state government more open, transparent, and accountable. Now, this can also be said for any state government as it pertains to the judiciary, because they're not accountable. The 1983 case is another example of a court system that does not want to be held accountable to the people it's supposed to serve, says Tim Potts, co-founder of the good government group DemocracyRisingPA.com. There should be no separation of power from any branch of government and its citizens. Citizens are the power in this system. The core requirement to being a successful judge is a basic knowledge of right from wrong, says Eric Epstein, coordinator of the nonpartisan voter education group rockthecapital.org. Now, I would have to disagree with Eric Epstein, because that should be a requirement of a judge, is that they know right from wrong. But when you have a self-regulated group that is out for itself, that teaches that everybody, or they should all think like a lawyer, they should think like a judge and not think impartial fully, but the more emphasis is put on thinking like a lawyer and thinking like a judge and doing things that will be in their self-interest, because, hey, these judges, if they don't act right, they're out. If they don't do the right thing to support judges and lawyers and fellow lawyers and judges, they're out of the loop. They've got to be, to be a judge, first off, you've got to be a brown noser. And by saying that, I mean, I don't mean to be offensive, but they do have to basically get the endorsement of the Bar Association a lot of times to be even promoted to the situation in which they are a judge. So I would definitely disagree with Eric Epstein. I would say that the core requirement to being a successful judge is to be a brown noser. And I say that, like I said, no offense, but when you look at the whole situation and the way it's self-regulated and everybody has got to be self-appointed, or not self-appointed, but endorsed by certain entities within the whole structure, it promulgates this. But let me go back to the article. But nothing about the state's shameless double standard for judicial candidates will change soon because March 6th was the candidates' filing deadline this year. And nothing might change at all because Feudale's ruling is an unreported opinion. According to different state, it's not going to carry any weight because it hasn't been published. But thank goodness that Benjamin Barton, professor, University of Tennessee College of Law, who will probably, unfortunately, not ever enter the legal profession because of his views. But thank good that his paper was published because I think it was a good paper, and I think you should pick it up and read it if you get online. Google Benjamin Barton. But that's all I had to say. Did you have any other comments or suggestions?
Any comments, Don?
No.
Okay. Well, thank you, Terrance, for that brilliant oration here on the court system. You know, one thing that Barbara Johnson says is this, or at least she comments from someone from the past. It's dangerous to be right when the government is wrong. Voltaire. Let's see if she had some other. She had one other thing that I thought was interesting. All truth passes through three stages. First, it's ridiculed. Second, it is violently opposed. Third, it is accepted as being self-evident. A quote from Arthur Schopenhauer. That dates back to 1780. His term was 1788 to 1860.
He was a philosopher, wasn't he?
Philosopher Schopenhauer. I told you that we would be talking a little bit about some of the things that the legislature needs to do some fixing up. But before we do that, we're going to call on Don to tell us a little bit about something called the class action suit in Iowa. The class action suit is going to be one way of bringing the attention of the Department of Human Services and the state legislature, bringing their attention to the fact that they are servants of the people and not their masters. They are the ones who are to be driven by statute, to be shaped, their actions should be shaped by statute and restrained by statute. Tell us a little bit about what the class action suit means to you, Don, and why individuals might want to look into joining a class action suit. Don.
Well, actually, I don't have an update on it, John. I'll just leave what your words said.
Okay. There is, you're in the class action suit, are you not?
We have no class action suit at this time.
Well, haven't you?
I'm not sure.
You're not sure what?
I'm not sure what to say to your answers. So
Okay.
I would suggest until we get more facts.
There is a class action suit being put together, and I know the individual who is heading up this effort is very interested in getting the word out on it, and to invite folks to join the class action suit in order to assert parents' rights. Join in a class action lawsuit to curb DHS abuse. And there is a site that you can, an email site that you can look into. If you're interested in making an inquiry as to what you can do as a person who has been or anticipates, and by the way, if you haven't been invaded by the Department of Human Services, I can tell you one thing: you're probably on their waiting list, because every year thousands of families are intervened upon by the Department of Human Services, and they are, for the most part, out of control. They operate on statutes which on their face are unconstitutional, and the ones that are not unconstitutional on their face, quite often the activities that are pursued pursuant to the statutes are unconstitutional as applied. So you might want to take down this number, Quails Echo with an E on the end at hotmail.com. And Don will probably be able to give you some more information on that. In fact, he'll be inviting someone to join us on this program to tell us about a class action suit. Class action suits will bring about some measure of attention to the problems arising with the Department of Human Services, and I welcome the change. I welcome whatever these public servants can bring with respect to improvements in what they're doing. I don't believe it's a good idea to tear families apart. God made a structure of the family, father, mother. I think of Dick, Jane, and Puff. Once was the ideal family, nuclear family. Now it is single parents, far too many single parents, far too many latchkey children, far too much child abuse because of the lack of parental supervision, far too much in terms of parents going out and working in order to pay the taxes so that we can have more and more services for families that are torn apart. You don't need all the recreational services. You don't need all of the daycare services if mom is at home, father is working. Of course, it doesn't make any difference to me who the breadwinner is. If mom wants to go out and earn the living, that's great. Father knows how to diaper the children and how to do the dishes. So from a gender standpoint, I don't have any problems switching gender, but I do have a problem in where both parents leave the household. Both parents are so exhausted that they cannot do a good job of raising the children in the nurture and admonition of the Lord, giving them the time and attention that children not only deserve, but the kind of a time and attention that they should demand. Well, it's virtually impossible if you're going to attack the family. If you're going to, like 60 to 80% of the divorces are filed by the female side of the of this divorce business, and a large number, in the neighborhood of 50% of the families, are broken up by marriage. This leaves a huge number of people who are involved in divorce, and a huge amount of government intervention, such as for child support and court services and all kinds of things that are a part of this family breakup. Well, here are some things I think that are needed as emergency measures. These are certainly not the be-all and end-all of the suggestions that I might be able to come up with for building a system which supports the family and holds off on this intervention. Is there a reason to have at least some minimal measures to protect children from abuse? Absolutely. Is there a reason for the Department of Human Services to exist in a small scale to help families? Absolutely. But minuscule in comparison to the kinds of intervention and the kinds of volumes of services that this organization wants to perform now, to the tune of $2.3 billion. That's a lot of money. It seems as though they want to make it bigger and bigger and bigger. They want to leave into the hand, or take from the hands of the parents, those cares and responsibilities that are better handled by parents, and place them in the hands of so-called professionals. And many of these professionals have no children of their own. Their lifestyle is not, in many cases, not the kind of lifestyle that even produces children. And when you find a 23-year-old graduate of the University of Iowa School of Social Work coming in and telling you how to raise your children when you're better off doing that job yourself, I think it's atrocious that we have to spend $38,000 and give the social worker a car to drive around and intervene and tell parents how they must raise their children. And if they don't raise their children in a fashion which is acceptable to the social worker, they can find them to be abusive parents, because their way of parenting doesn't match the way that that the social worker believes to be appropriate. Then it calls for intervention, which is in and of itself disastrous, both for the children and for the parents. You know, it crossed my mind today that once upon a time there were services that were delivered to the home. When I grew up, milk was delivered to the front porch. The garbage was picked up by a gentleman who had a team of horses. Yes, I'm that old. The milk was delivered by horse and a wagon. The horses and wagons were headquartered just across the street from the Mercy Hospital complex on the north side of University between 2nd Avenue and 4th Street. So we had all of these services. When you called a doctor, the doctor came to your house. The insurance man came to your house to pick up premiums for your insurance. We had all of these things delivered to the home. I think it's because of economics that we don't do that anymore. You can't afford to charge enough for milk to have it delivered to the home. You cannot pay a doctor enough if he has to go from house to house to make house calls. When I was young, I think that the doctor charged for a house call was $4. Yes, I'm that old. You see, the situations have changed enormously in the past few decades, to the extent that we don't make house calls anymore. I say we don't make house calls anymore? Yes, we do. The social worker makes house calls. Is it expensive? Is it inefficient? Yes, it is. When you pay a social worker beginning wage of $38,000, give him or her an automobile to drive around, give them an office and office furniture and support personnel and supervision, it is an expensive ordeal for that worker to intervene in your life and to micromanage your business. How about divorce situations? Do they come and pay a call? They would love to have you as a part of their caseload, because the more people they have in the child support system, the more people they can hire for child support. And the government picks up the tab for the child support administration. Now, they do not like for you to pass the money off to your ex. privately, because that is not counted as a case for the government. And without hundreds of cases, they can't hire the next worker, and they can't draw down federal funds. Now, what kind of a deal is it where we have turned to micromanaging families on a one-on-one basis? We make house calls, we intervene, and the costs are absolutely enormous. Perhaps we should think of the social services system as a part of a much, much smaller organization, one that is targeted to specific needs, not one that wants to go roughshod over individual families. But that is not the way that it's operated today. And I think the class action suit needs to bring some news to bear in this area, that we need to let our servants know that we don't need the kinds of services that they have to give us, or the kinds of services or kinds of intervention they wish to impose upon us. Number one, this is one of the recommendations I've talked about on this program for a number of years. And it's not just my recommendation. This also comes from the Iowa Ombudsman, if that means anything. But to establish a centralized intake unit manned 24/7 by highly skilled DHS workers. Perhaps they don't have any highly skilled DHS workers. But if they're going to pretend to protect children, we need somebody that is on the phone, not somebody who is handling phone messages at a critical time when somebody picks up the phone and says, I know that a child is being abused, and I want your immediate attention to this problem. That has grown completely out of proportion, and it becomes a plaything for people. I call it an indoor sport for the feeble-minded. When they call up on neighbors, upon landlords, upon employees or employers, somebody that you don't like, pick up the phone and call them in to Child Protective Services. Now, statute requires that something be done about it. But statute also has set up a system whereby that can all be done by telephone. However, statute has not dictated a good way of doing it. Statute has not said, look, when somebody picks up the phone, they want to talk to someone who is knowledgeable of the system, not somebody who handles a handwritten note put on a fax machine that is faxed the next day to the closest DHS office. A ridiculous concept in today's world, where much of the business is done, where there's telemarketing or whatever else, is done on a centralized basis. Can you imagine running a telephone repair service, for an example? I called up one time and needed some attention from the telephone company because the wires had drooped from my home. Someone from Miami answered the telephone and dispatched a lady who lived 3 blocks away from my home, who came over on a Sunday morning and gave attention to that. Now, do you suppose it would be wise to have operators all over in every geographical region to answer phone calls like that? No, they had one person in Miami who knew what they were doing and knew where the resources were and could apply the resources by telephone to get the job done on a very efficient basis. DHS doesn't believe in efficiency in their business because the more efficient they are, the fewer the people they would need on staff. So I would go along with the recommendation of the Department of or the Iowa Ombudsman, and a few legislators who said it's a good idea. In fact, they said it was such a good idea that it became the key recommendation of a $140,000 study that was done by the General Assembly. The General Assembly also said, here's another $250,000 to get it off the ground. They don't have it off the ground yet. It's efficiency, and they're not interested in doing things in an efficient manner. So, number one is establish a centralized intake unit manned 24/7 by highly skilled people who know what they're doing, and make that unit totally segregated from all other phone services. Don't dial the 211 or the 911 and all that sort of stuff, and route them to different places. When you have a child abuse report, you ought to be able to talk to a child abuse expert on the line and get the job done right then and there. And before you hang up, you should get a commitment from that person whether or not the information is sufficient to commence an investigation. None of this callback, none of this reporting back. The grounds are well established so that the person answering that phone should be able to tell you in a moment's notice whether or not the information that you're giving will result in a real investigation. That telephone call needs to be digitally recorded, a voice print, so that if someone else is going to assist in the investigation or in working with it, that it is voice printed, and that information can be passed to them very accurately. This is done in the state of Montana. Identify all intake sources so that we know how to go back and contact those people for additional information. A lot of this arose because of the Shelby Dewis case, where there were 25 referrals to the Department of Human Services, but they weren't interested in giving proper attention to each one of those sources. This needs to be done on a business-like basis. We need to have enough care and for our children and their safety to do it right. DHS does not know how to do it right. So I'm saying that we need to identify all those intake sources. The DHS must transact the call by returning the call to the number given initially. That way you call back, and if the person can't be reached by the number they gave you, then you forget that call, scratch it as being a crank type call. Eliminate the permissive and the mandatory reporting. Mandatory reporting is nothing more than involuntary servitude, a real pleasant term for slavery. It assigns to a person the duty to do detective work far beyond their normal job description. I think a person who is a professional that doesn't report, it's a sad commentary. But I don't see any reason why the government should compel somebody and to make it criminally a criminal act if they don't report every single thing. It makes everybody a stool pigeon, and that is not the kind of society we should be living in. So I'd say eliminate the permissive and the mandatory reporting. By the way, it doesn't take long to train a mandatory reporter if you don't have any mandatory reporters. So all that training budget can be set aside for something more productive. Restrict the placement on the registry to court-ordered placement. If the court hasn't said this person is guilty, don't put it on any registry. This shouldn't be a toy for social workers to play with. Prohibit placement on the registry prior to the exhaustion of all appeals. People should have appeal rights. Prohibit employment inquiry from prospective employees or applications for membership in any association regarding the placement of or hiring of an applicant or whatever. Just check to see if they're on the child abuse registry. That's not what it's for. The purpose of the registry is set forth in statute, and it shouldn't be used for everything else. The number of people that can get to be on the statute now covers several columns in the statute books. I think this is totally ridiculous. That registry should be used for one and only one purpose, and that is for follow-up and to establish whether or not there's been previous problems with either the victim, the alleged victim, or the alleged perpetrator. That should be the only purpose, and that shouldn't. Those things should never be sent to the county attorney's office. That's not a part of the county attorney's work. Prohibit employers from making inquiry as to whether you are on the registry, so that when you fill out an application, you have to answer whether or not you've ever been on a child abuse registry. Expunge all of the reports. There's 49,000 of them on the registry right now, and start from scratch. Require sworn to affidavits in support of any action or referral taken by the Department of Human Services to the juvenile court, the district court, or any other referral not specifically approved by the parents of the child. So if they're going to take any action that arises from an investigation of child abuse, all they have to do is make a sworn statement of the facts of the case. Right now, they can throw into your lap the whole idea of they can throw into your lap a whole list of things that you may have done, and you have to guess which one they're going to charge you with. Well, that is not the way to run a railroad. I think they need to stick to statute, and in working with the citizenry, they need to be within something called due process. That is a constitutional right, and I think it's a shame that we are not exercising that right. Class action may be helpful. Here's a couple of telephone numbers that could be helpful to you as you pursue your rights with the Department of Human Services and the Juvenile Court. See you next week.